Good evening and welcome to the Teske Brief. I'm Judge Steven Teske, retired. In this series titled The Bar Card and the Breakdown of Justice, we examine one of the most important stories in American law and government today. What happens when the lawyers entrusted to enforce justice begin to fear the very system they serve? Now, across this series, we explore why experienced prosecutors are leaving the Department of Justice, how political pressure can distort legal judgment, why independent courts and state bars still matter, and what is lost when institutions ask for power but stop earning trust. Folks, this is not merely a story about personalities. It is a story about professional duty, constitutional guardrails, and whether the rule of law can survive pressure from power itself. And tonight's episode is titled The Prosecutor's Dilemma. So before we begin, remember, titles are temporary, power is borrowed, integrity is tested when pressure arrives. And this is the Teske Brief. Welcome back. Most ethical collapses do not begin with a villain petting a cat in a dark office saying, "Excellent. Now let's violate the Constitution." No, folks. They begin with a meeting, a deadline, a look from the boss, a sentence like, "Are you a team player?" And suddenly we arrive at tonight's topic, the prosecutor's dilemma. And recently, the public got a rare glimpse into that dilemma from someone who actually lived it. Former Department of Justice lawyer Erez Reuveni was fired for refusing to sign a brief containing statements that were false and could not be corroborated. He decided not to take it sitting down and filed a whistleblower complaint describing what he says he witnessed during his final weeks at the Department of Justice. Folks, Erez is not a political pundit. He is not a Twitter activist. He is a career DOJ lawyer, a person who had spent years inside the institution. And listening to him, what stood out wasn't theatrical corruption. It was something more familiar and, frankly, more dangerous. Pressure, normalization, the gradual expectation that lawyers defend positions they do not believe are lawful. Now, throughout this series, I've talked about the pressure prosecutors can face when politics, institutional loyalty, and ethics collide. But I want to hear from someone, and I want you to hear from someone, Erez Reuveni, who actually lived it inside the Department of Justice. Former DOJ lawyer Erez Reuveni recently spoke publicly about what he says he witnessed during his final weeks, right? He's not a political commentator, not a cable news personality. He's a career government lawyer, someone who believed in the institution. And I want to walk you through his words carefully because they capture exactly what the prosecutor's dilemma looks like in real life. Now, before you can understand why someone walks away from the Department of Justice, you first have to understand why they joined it. Listen to Mr. Reuveni describe what DOJ meant to him.
Francisco for a brief period of time, but I always wanted to get into public service. And the key marquee place to do that, everyone understood at the time, and I still, until recently, felt this way, was the Department of Justice, because right away, you are leading big cases, you're standing up in court, you're saying Erez Reuveni on behalf of the United States. You're not necessarily saying Erez Reuveni on behalf of some large faceless corporation. You're here really representing the people of the United States. And the thing that I've always thought about when trying to explain this is there's this Supreme Court case from 1935 in which the Supreme Court tells you what it is to be a government lawyer. And the role of the government attorney, the Supreme Court writes, is not simply to win. It's to make sure justice is done. And that's the thrill of standing up in court and saying your name on behalf of the United States.
Folks, that matters because this wasn't someone hostile to the institution. This was someone who believed in it, which is why what comes next becomes so important. The prosecutor's dilemma doesn't become painful unless the lawyer actually cares about the oath that they took. Now listen carefully to what happens when institutional pressure begins to overtake legal judgment.
So Bovey, who again is leading the meeting, tells everyone in attendance that this invocation of the Alien Enemies Act to remove certain Venezuelan nationals is of the highest importance to the White House. And after a pause, emphasizing to everyone again in the room, those planes have to take off, quote, no matter what.
Okay, that sentence may sound simple, but lawyers listening to that immediately understand the danger. You see, because prosecutors are not supposed to start with the outcome and then work backwards to justify it. No, the question is supposed to be, is it lawful? Is it constitutional? Is it supported by facts and the evidence? Not. Now, how do we make sure this happens no matter what? That is the moment the prosecutor's dilemma begins. Now, comes the moment where ethical discomfort becomes something much more serious. Now, listen carefully.
And then there's another pause there. And then this is the thing that sets the tone for the next 3 weeks. Bovee says, and if some court were to issue some order that prevents that from happening, we would have to consider telling that court, quote, fuck you.
Now, for non-lawyers listening, let me explain how extraordinary that statement is. The entire justice system depends on lawyers being truthful with courts. Not because lawyers are perfect, but because the rule of law collapses if government attorneys stop treating judges as constitutional authorities whose orders must be obeyed. That's why prosecutors have a heightened duty of candor. And when career DOJ lawyers hear language suggesting the court itself can simply be ignored, that's not ordinary disagreement, ladies and gentlemen. That's institutional alarm bells going off. Now, listen to Mr. Reuveni describe his reaction internally.
I felt like a grenade had gone off. Like, is he serious?
That statement right there, okay, tells you everything. That is not politics talking. That is not ideology talking. That is a lawyer realizing the institution he trusted may no longer be operating by the rules he was trained to follow. And once that realization happens, every decision changes. Because now the lawyer has to ask, well, do I stay? Do I object? Do I sign this? Do I risk my license? Do I walk away? That's the prosecutor's dilemma. And now Mr. Reuveni explains the line prosecutors are never supposed to cross. Hear this.
Because we are now at a point where we've admitted we did something wrong, the government, but instead of fixing it, we're just making stuff up about this person and signing a brief under penalty of perjury that we are submitting to the court. And so when that draft brief comes around, that's the line, because that's us lying to a court, and that's me signing my name to that lie. And that is not something I signed up to do when I joined DOJ, or frankly, what any attorney should be doing at all on behalf of any client.
And then, in a separate interview with CBS 60 Minutes' Scott Pelley, which you can find on YouTube, Mr. Reuveni was more direct, stating, quote, "It is the highest, most egregious violation of a lawyer's code of ethics to mislead a court with intent," end quote. And you know what? He's absolutely right. You can get disbarred for that. Exactly. And this is why the bar card matters so much throughout this entire series. Because political appointees may come and go, presidents can leave office, administrations in, but lawyers remain subject to the professional ethics rules long after the political moment passes. That's why so many experienced DOJ lawyers are leaving. Not because they suddenly forgot how prosecution works, but because they understand exactly how it works and exactly where the ethical lines are. And finally, listen to why Mr. Reuveni decided to speak publicly at all.
So I've come forward because the Trump administration has put civil servants in this impossible position of fealty to the president and the agenda, or fealty to uphold the Constitution and to uphold the rule of law. And time again during those 3 weeks, I was put to the question, which side am I going to be on? And ultimately, I didn't sign up till Iowa court. And that's the position I was put in, and that's the position others are being put in. And that's why I've come forward.
Stated in another way, Reuveni told Scott Pelley this on 60 Minutes, quote, "I would not be faithfully abiding by my oath if I stayed silent right now." Wow. That may be the clearest expression of the prosecutor's dilemma anyone could give. Because eventually the conflict stops being career versus promotion or loyalty versus ambition. Eventually it becomes silence versus conscience. When enough career prosecutors begin saying publicly that they believe the institution is drifting away from due process, ethical restraint, and constitutional norms, the public should pay attention. Not because prosecutors are always right, but because experienced prosecutors know exactly how dangerous prosecutorial power becomes when evidence starts taking a backseat to pressure and outcome. And that is the dilemma now confronting the Department of Justice. Reading this moment, it's hard not to think of President Trump's old television show, The Apprentice. Every episode built toward the same line, "You're fired." And one person held the power. Everyone else performed for survival. People adjusted themselves to satisfy the boss, avoid blame, and stay useful for another week. Ha! Good television, right? But terrible structure for the Department of Justice. Because DOJ is not supposed to operate like a reality show where lawyers compete to satisfy one person at the top. It's supposed to function as an institution governed by evidence, law, and independent judgment. But when prosecutors fear removal for refusing weak cases or for failing to successfully execute politically desired ones, the culture starts to look less like justice and more like casting. And that is a dilemma no ethical prosecutor can truly win. Bring the case and risk violating professional duty, refuse and risk retaliation. Fail to produce the desired result and risk replacement anyway. At that point, resignation may become the only remaining act of independence. And that is a tragic thing to say about the Department of Justice, because when institutional knowledge walks out the door, what remains is not always strength. Sometimes what remains is just simply obedience. And justice cannot survive if obedience becomes more valuable than the truth.
We are quickly seeing that when you have people like Pam Bondi and Todd Blanche, and before them, Emile Beauvais, who view their job not as to represent the people of the United States, as every federal prosecutor states when they stand up in court, but rather to represent the White House. You no longer have a building full of public servants. You have a building of in-house counsel. And that is not what the country needs, and it is not what the executive branch's oath to the Constitution requires.
Well, let's just talk about the fact that why we have a building full of in-house counsel is because the idiots that are running the department keep firing all of the public servants. And this is Todd Blanche bragging about firing 200 prosecutors at CPAC back just a week ago, March 26th. Just take a listen.
I represented President Trump in the Manhattan DA case and in Jack Smith's prosecutions. There is not a single man or woman at the Department of Justice who had anything to do with those prosecutions.
How many have been canned?
Over 200. Over 200 either left before we came in because they knew it was coming, or were fired, or took early retirement. They are no longer employed by this department.
So, dum-dum, when you do that, right, and you wonder why Pam Bondi and others can't go out and actually prosecute people because, A, you don't have the attorneys in place to do it, B, the ones you do have were just brought in from, Acme prosecuting company down the street, and don't know the case file, don't know the seriousness of what the matter is before them. So where does the department go when you've got the idiocracy firing the good people, bringing in hand-me-down lawyers? Sorry, but that's what you are at this point, because you don't know what you don't know.
There's also a myth worth killing here, folks. Some people think declining a weak case is cowardice. Sometimes it's the bravest thing in the room. It can take more courage to tell power no than to tell a defendant guilty. More courage to close the file than hold a press conference. More courage to disappoint the boss than impress the crowd. That kind of courage rarely trends, but justice depends on it. The prosecutor's dilemma is not merely personal. Folks, it is constitutional. A free society needs prosecutors who can exercise independent judgment without punishment for doing so. It needs room for dissent, disagreement. It needs leaders who value caution as much as aggression. And it needs citizens who understand that cases never filed may be as important as those that are. Because when prosecutors must choose between obedience and ethics, the warning light is already on. And when career prosecutors begin publicly describing what they saw inside the institution, the public should start paying attention. Ladies and gentlemen, I'm Judge Steven Teske, retired, and this is the Teske Brief. Thank you for being here and listening. And remember this, justice depends not only on who says yes, but on who still has the courage to say no. Until the next episode, y'all take care. Be safe. Bye.